I don't think I've ever seen a judge be removed. So, and if you guys want a very quick recap on this case, so hold on, let me just go to the next slide. Yeah, the Supreme Court removed Judge Barbara Elmore from the Aaron Spencer case. Y'all, this is Barbara Elmore. This is what they have on the website. This is what she looks like. And someone else, our anonymous source who's been giving us like insight from the courtroom told me that this is actually like, looks like her, like a good day, that she actually looks beat up compared to this. But this is what she's had on the website for, I guess, the past like 50 years. So I just wanted to make sure we had an accurate photo of her. But for those that do not know the case, basically, this guy, he had essayed. So this is Michael Fossler, had assaulted Aaron Spencer's 13-year-old daughter, and then he was arrested. They found 43 charges related to the arrest for her, 43 SA charges, and then there was like a restraining order. And then this woman, Judge Barbara Elmore, let him out he only had to pay $5,000. It was a $50,000 bond. And so he was out. And then 3 months later, Aaron Spencer's woken up in the middle of the night by the dog is barking. So he goes and checks on his daughter's room. She's missing. They then track her phone. The mom calls 911. Spencer tries tracking her phone, gets in his car, goes after, then sees like that she's in the car with Michael Fossler, who like there's a restraining order against, and obviously he fears for his daughter's life because she is the sole witness that is she's going to be the one who's going to be able to put him away for the rest of his life. So he does like a pit stop maneuver to get stop Michael Fossler, get him off the road. This is a trained Army veteran, by the way. And then he gets in a confrontation with Fossler, and then he ends up unloading his pistol on Fossler, pistol whips him, gets his daughter, gets back in his car, reloads his gun, calls 911. It's like, you better pick up this PDF file who's dead on the side of the road. Then he ends up getting arrested, and the same DA's office that found that this guy was so dangerous, they were able to charge 43 SA charges against him, right? That same DA's office like arrested this guy and charged him with intent to murder, because they said he had intent, because 3 months prior he said that he wanted to hunt this guy down, which he never did, which is like that. It wasn't until an act of kidnapping that he went and he saved his daughter. She was in imminent danger, and it was self-defense, and he went and he saved his daughter. So this judge was somehow Aaron Spencer's case ended up on this same judge's desk. How? I don't know. Like, isn't that weird? You would think she would have had the wherewithal to remove herself, but she didn't. And so Aaron Spencer's team, because at first this judge did the most, like, she did an extreme gag order, sua sponte, which means like without either side asking for it. She did it on her own. It was a handwritten gag order. She also did the arraignment in private and secretive. And then, so Spencer's team filed like a motion to the Supreme Court to get the gag order reversed, and they vacated it. And not only did they vacate it, but they recommended she step down from that case. Okay. So that was back in March 2025. So she didn't step down. She made some terrible rulings that was this last Friday, you guys? Now it's like so crazy. Let me see what the date is on my X for this. Okay, the 23rd. Yeah, I can't believe this was only a week ago. So last Friday there was a hearing, and they were going to about the grooming expert that she had denied, and his team wrote like they appealed her denial for their witness. Because the DA's office was trying to say that the daughter somehow left willingly. I don't know how that's possible. She's a minor. This sicko was 67 years old and had a restraining order. I don't know really how she could go willingly, but that's what they were saying. And so then Aaron Spencer's team wanted to present an expert on grooming, because they wanted to explain to the jury why the daughter possibly could have left willingly, because she was groomed. And this awful wicked witch of a woman said that it would confuse the jury, because this was not a case about SA. It was a case about homicide. So Spencer's team went all out, and they filed to the Supreme Court. So now that they knew, the Supreme Court of Arkansas told her to step, like they recommended she get off the case and she didn't. And instead she kept making completely biased, insane rulings. His team went full force and filed things with the Supreme Court. And then now we get to the punchline. What is this? Oh, okay, wait, let's see if I have, yeah, so here was this, because they knew how the Supreme Court fell. So then this also happened Friday. So on Friday so the judge refused to recuse herself. So again, so because they had filed like a formal motion, she refused. So the trial was supposed to start this Monday, okay? And then there was going to be a weather delay. It was going to start today, Thursday. But then on Friday, the Supreme Court, they told the judge to step down. So it says petitioner's petition for writ of certiorari, is that how you say it? And other relief, emergency consideration requested, expedited consideration granted, petition for writ of certiorari granted, writ issued, Circuit Court's January 13th, 2026 order limiting courtroom occupancy and no recordings vacated, because that was the other thing. They wanted to limit the courtroom occupancy, and they wanted it to be not recorded for no reason. She never even gave a reason. 23rd Judicial Circuit Judge Division 1, Barbara Elmore, removed from this Aaron Spencer's case to be reassigned to a special circuit judge appointed by this court. And then these are the people that would deny the petition for the writ of certiorari, which that's the part where they basically have the new judge go and look at every ruling the judge has made in this case. But the Supreme Court granted, it's just those are the people that would have denied it. So something's obviously wrong with their head. And then it said the case is immediately stayed pending this court's appointment of a special judge. In testimony that the above is a true copy of the order in said Supreme Court rendered in the case stated therein, I, Kyle E. Burton, clerk of said Supreme Court, hereunto set my hand and affix the seal of said Supreme Court at my office in the city of Little Rock on this 23rd day of January. And this just warmed, I posted on X that this warmed my jaded little heart, because I mean, this is like an impossible thing. This is almost impossible. We actually saw one more judge removed this week in a different case with I want to say it was in Atlanta with some rapper or something, but so it happened after this. So that two rare things happened at once. But like, again, besides that, you just never see this. And but if there was a case where a judge needed to be removed, it was this one. And I actually was talking to some because we have a legal committee for the land that I'm trying to save. And I was actually just talking with them, and I mentioned this to them just to see, I'm like, have you guys in any of your careers in your fields of work ever seen anything like this where the judge is removed after especially this is the second time the Supreme Court's had to intervene, because they actually had already suggested she should step down. And they're like, no. And they're like, usually they're like, it's very rare even for the Supreme Court to suggest that. And if they do, the judge would immediately step down. They've never and this was people who have even gone in front of the Supreme Court. So I just thought it was pretty interesting. Yeah, because she's a nitwit. Yep. It was a huge risk by his lawyer because he could have been burned. Yeah, exactly. Because they could have said no. But I think that they knew that I think that they already knew how the Supreme Court would rule based on what they had said before, how they thought that she should step down. Kay Bella says 13-year-olds are not allowed to choose to go to willingly with pedos. I know. It's just insane. This is so embarrassing. But we're not even done yet. We're not done yet, because things are just about to get even better. So let's keep going. I've never even seen this. Okay, so this came out. The date is before, but we saw it the same day on Friday. Okay, so this is from the state of Arkansas House of Representatives. And it says, and this was a letter to Miss Emily Abbott, who's the executive director of the Arkansas Judicial Discipline and Disability Commission. Dear Director Abbott, as a member, can you guys see this? Sorry, I just want to make sure it's big enough. Did I take all the comments off the screen? You guys can see us, yeah? Okay. Let me go back. Dear Director Abbott, as a member of the Arkansas General Assembly, we write regarding the ongoing trial of Mr. Aaron Spencer in Lonoke County. We have serious concerns about whether he is receiving a fair trial, and we believe these concerns require our attention as legislators. The Arkansas Supreme Court has already intervened in this case. The court found that the trial court violated Mr. Spencer's First Amendment rights through an overly broad gag order. This is not speculation. It is a documented ruling that constitutional violations have already occurred in this case. And then she quotes the Spencer versus the state of Arkansas. They support, and they quote Judge Justice Bronny, his concurring opinion. So that was pretty funny because we read that. Remember, we love Justice Bronny. He did not mince his words. He went really hard on her. Recent court orders continue to raise concerns. The trial court has restricted public's access to the proceedings and deployed extraordinary security measures. These actions create conditions that may prejudice Mr. Spencer's right to a fair trial. The restrictions appear excessive and risk undermining the presumption of innocence to which every defendant is entitled. As members of the legislative branch, we have a constitutional duty to ensure accountability across all branches of government. The Arkansas Constitution gives the legislator specific authority over the conduct of all public officials. We respect judicial independence, but we take our obligations seriously to ensure that constitutional rights are protected. We do not ask anyone to prejudice the evidence. We do insist that Mr. Spencer receive a fair trial that meets constitutional standards. Judicial conduct should be reviewed to ensure that the pattern of violations does not continue. Look at this. Look at all these state representatives that signed this. Oh, it's not done yet. Hold on. We trust that existing oversight mechanisms will address these concerns. However, if the documented pattern of constitutional violations continues, we are prepared to fulfill our constitutional obligations by using the full range of powers entrusted to us by the people of Arkansas. We call on state leaders and the judiciary to ensure that a fair and constitutional justice is done in this case. And then it's respectfully, look at all these state representatives. I mean, Barbara Elmore. I mean, not only is this so embarrassing, such a bad day, and the DA's office for freaking supporting her and trying to like justify what she was doing on this case. Shame on them. But this is embarrassing for them too. I mean, look at that. I mean, I don't know who these state representatives are, but like, I mean, let's count it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 of these state representatives signed this about her. I have no words, like her unacceptable, oversight of this case. Are you guys blown away yet? I need to see the chat. Let me get back in here. Oh my gosh, I have a new member. Mr. Busted Can of Biscuits became a new member. Thank you so much. Or sorry, Mrs. Busted Can of Biscuits. Well, thank you. I really appreciate it. Welcome to the crazy train. Where did you go? Uh-oh. Did I disappear? I want to make sure you guys don't see me. 3 of the Arkansas Supreme Court justices wouldn't look at it. Yeah, well, screw them. Okay, I just want to make sure I'm still here. Yeah, that's right, Barbara. You're fired. You are fired. Okay, you can hear me now. Okay, sorry. That's so annoying because I just fixed like my internet. So it like had been dropping a lot like the past few days. And so today I fixed it and now it's been working great. So if it goes out again, let me know though. Definitely. Yeah, it's been nuts trying to catch up, right? Yeah, that's how bad she was. It's just insane. Absolutely insane. So, but things get worse. Okay, are you guys ready for this? Things get worse for Barbara Elmore. So, let me take you to let me see if this will just let me open this. So, Judge Barbara Elmore hit-and-run surveillance footage. Is this woman drunk? Yesterday, the Supreme Court of Arkansas removed disgraceful Barbara Elmore from the Aaron Spencer case just days before trial was set to begin. And then we get this footage. And I'm going to show you, I'm going to link, it's already linked in the description, but I want to make sure that I give credit where credit's due. Because this, here, I'm just putting it in the chat right now. And let me actually share this tab. So this guy, Jimmy Cavan, he's the one who got us that photo of Barbara. And he's the one who got us the surveillance footage. So she hits this is her driving to work, okay, at the courthouse. Can you guys see this? Let me make sure. Okay, let me see if I can make it bigger. Hold on. Okay. So she's trying to park. This is like 9:30 in the morning. She sideswipes this car next to her. And then she realizes that she sideswipes it, right? Okay, so now she's trying to back up, but then she's stuck, you know, because you're these things, your rear view mirror, she got stuck in the car. So she can't back up. So then she just keeps going forward over the edge, over the sidewalk, and then drives back around. She's like, uh-oh. So then she's going to drive back around and park. And then she's going to walk into the house, back into the courthouse. I'm going to fast forward it so you can see it. Okay, that's her walking. She checked out her work. Didn't leave a note. Just keeps walking. Throws something away. Probably like those bottles of alcohol or something, because allegedly, in my opinion, that's like the wacko. So what happened was the owner of this car filed a police report that like someone hit their car, and then they found out so this was from July 18th. So this was like after the Supreme Court told her not like that she needs to get off the Aaron Spencer case. Okay, so this was last July. Yeah, 9:30 in the morning. So, and it says, spoiler alert, she got away with it. Of course she did. So this guy is awesome. Because I think he did one more. Yeah, so I have to give him credit too for this photo, because I don't think we would have had this photo of her. So yeah, it just says, he basically says everything that we just said. Okay, so later that day, an officer arrives to the scene. He inspects the woman's vehicle with her, and then they both enter the courthouse at 1:30. At that point, the incident was over. Now that fact has infuriated many, wondering and asking why Elmore was not arrested and charged. Did she use her position and power as judge to escape accountability? Well, the answer to that is yes and no. For the Lonoke County PD, they did about all they could do in this situation. Let me explain. I talked on the phone with the chief early Thursday evening. He confirmed the incident took place and that Elmore was driving the vehicle that struck Frazier's. He stated that there was no incident report on the matter, but acknowledged there should be dispatch records on it, and assured me that when he got to work the next morning, he would access and send them to me, which he did. The dispatch call report provides facts that help paint the picture. According to the report, the request to LPD for an officer was made by a woman who works in Lonoke County Judge Doug Irwin's office, stating that a white SUV hit Miss Frazier's vehicle and left the scene. Then we have like the dispatch call right there. That tells us at that point, no one still had a clue it was Elmore who committed the hit and run. Note the timestamp on the surveillance video and the report are slightly different, which is a common occurrence. And then it just said, no incident report was generated. Further, I researched laws. Okay. It was a hit and run with a vehicle, which is a 10. Okay, so the penalty for violating the code ranges from Class A and B misdemeanor to a Class D felony, depending on the amount of damage. Frazier's vehicle was not attended. On the other hand, AR Code 2753-104 addresses a hit and run of an unintended vehicle. As you can see, it has no penalty. And so then it has the code. So there's no penalty, I guess, for hit and run in Lonoke County, Arkansas. Do I think the law is just? No, but it is the law. At that point, there's really nothing LPD can do. I have to say I'm impressed with the chief's prompt response and transparency. That is a refreshing 180 from the past LPD chiefs. I also reached out to Elmore and Frazier for statements on Friday morning. I spoke to a lady in Elmore's office explaining in detail the request and left my number for her to call me. I have yet to hear from her, and Smart Money says I never will. My attempts to speak to Miss Frazier were unsuccessful. However, Miss Frazier's husband, John, messaged me this morning confirming Elmore agreed to pay for fixing their vehicle and said she did just that. What a saint she is. Yeah, so anyways, I linked that. Crazy, right? This is, I'm telling you, this is absolutely banana town crazy, this case. The fact that like I cannot believe there's not more coverage, really. Like this is something you would think like long crime would be all over. Like I mean, I was watching like what was that? The au pair, the Brendan Banfield trial today. Like yeah, that case is crazy. But like this case is like also crazy. This is like so insane. I just, you never hear of a judge getting removed. That could easily be drunk or entitled. Or drunk or entitled, yeah. Oh, yeah, thank God for cameras. All day drinking, I know. And so, oh yeah, so let's keep going. Because this just led to, all right, let me go to my slides. This is kind of, now I don't really remember what the rest of my slides are, you guys, so it might get a little crazy. Okay, so I went to the comment section where this video, because it was also posted like on the Justice for Aaron Spencer Facebook page. And it says, not very honorable behavior. What other crimes has she hidden? And then someone says, is there body cam footage of the police interviewing Elmore regarding the incident? And they said, if it is, it's missing, I'm sure. And that, what is that? That's a throwback, because there was a SD card from Michael Fossler's truck of the, of the incident that could have helped Spencer, could have like shown what had gone down that night, where he had taken the daughter, what had happened between him and Spencer. And that SD card mysteriously went missing. And also, then we found out that like one of the officers lied about it on the stand, it seems, because he said, oh, well, when I watched it, there was just, it was just 15 minutes of flashing like blue and red lights from when the police were there, which means if it was recording when the police were there, it had to have been recording from before. And also, that model doesn't record in 15-minute segments. It records in 5-minute segments. So there's no way this officer could have just watched like 15 minutes straight. There would have been segments. And so we think that there was something shady going on there. Mishandling of evidence, It says, this isn't the first or even second time. A few years ago, she got into a wreck. Oh, sorry. Am I not sharing this? Sorry. All right. Now I should be sharing it, right? Yeah. Okay. So this one says, let me go back. This isn't the first or even the second time. A few years ago, she got into a wreck in a parking lot because she was drunk, and the sheriff's office gave her a ride home. No tickets, no tow, no speaking of it, just gave her a ride home. No harm, no foul. The accumulation of all the things she has done and got away with needs to be heavily investigated and would more than likely lead to prison time. Like, you guys, people in Lonoke County, like, they know what's up. The comment section was getting me. And then it says, was she drunk? And then it says she was breathing, so probably. And says, I've heard things along those lines. She even wears an ankle monitor. Now, I keep hearing the ankle monitor thing. I don't think that's a thing. I think, like, even if you did have a bunch of DUIs, I don't think you would get an ankle monitor. I think, like, if anything, she should have had one of those, like, breathalyzers that you have to blow into to start your car. But she doesn't, because she's a judge. And she knows there's a camera. And then it says, John Fraser, isn't this your wife's vehicle? And then it says, I've heard she wears an ankle monitor, but I don't know if it's true or just a rumor. See, I keep seeing that. And then it says, that's my sister-in-law's mother's vehicle. So check out the comment section on that page. That's pretty funny. It's the Justice for Aaron Spencer Facebook page. Now we're going to get into the court documents. So sorry, I just want to take that. So before I switch, I want to make sure I have, a good screen up. Okay. So this is linked in the description, but I'm going to link it in the chat, because the thing is, all of these documents are, they're like cached. They only last for like I don't know, like 10 minutes or something. The link, and then the link, you have to get a new link for every document. So I can't just like give you guys the links to the documents, but like I can give you a link to the file, and then you can download whatever documents you want. If that makes sense. Kenny says, why aren't more people covering this? I don't know. Well, this is what I honestly think, because I think that gag order did what it was supposed to do. She put in that unconstitutional gag order where it was unconstitutional. It was like no one was allowed to talk about this case at all on any side. And so there was like a blackout in the media. So I think a lot of people forgot about it. And then also the judge had said that in the courtroom, there would be no cameras allowed. There would be no live coverage of it, no live feed. So I think a lot of the media was like, okay, well, like this is going to be a waste of time to report on the story anyways, because like we can't cover it, we can't capitalize it, we can't build it up, because you know, like no one's going to actually see what's happening. So I think that she did it intentionally so that people wouldn't cover it. People forgot about it, but we didn't forget about it. Hold on one second. I'm going to get some tea. Okay, I'm back. And Elmore said you couldn't question the officer's truthfulness. Yeah, she did. She said so many things. Can you make that a video? Can you make that a video as short with Keystone Cops music, please? Which one? The car? That was so funny. I mean, this is so bad. She's retiring in November, but in my opinion, like she needs to get off. She needs to walk away now. Like leave now before you do anything else worse. Oh my God, Kay Bella, she's the raisin eyes of the court. Oh my God. Thank you so much for the super chat. That is so true. She's the raisin eyes of the court. Yeah, well, they say, justice, what do they say? Is justice is blind? She's certainly blind, in my opinion. But they say that they're not supposed to be biased. But she was very, very biased. And just there's no way she should have been handling this case. So we're gonna read something. And I just want to see, are you guys worn out? Like, do you want me to do this in a different live or you still want to stay here? Because, yeah, Lori Jane says, I didn't forget. Oh, wait, let me go. I see Vague said something. I missed it. Oh, look, Prickly Pear says, this case is on the same level as YSL case in Georgia that went through 3 judges and 2 attorneys were arrested. Oh my God. That case was so crazy. And I remember that was Brian Steele who, like, the judge was like, I'm going to hold you in contempt. And he's like, well, then can you at least make sure I'm put in the same cell with my client so we can work on our case? Like, that case was insane. And, oh my God. And those jurors, they were on jury duty for was it over a year? That case, yeah. This is right up there, though. I agree with you. Yeah, hit and run is not a crime. Well, it says if the car is unattended. But if there's someone in it, it's a crime. But if not, it's not. They need to change that law. Vague says, oh, I missed that. Wait, oh, it was up here. I'm sure it was an honest side swipe. We've all been there, right? Oh, wait, no, we haven't. I know, right? Oh. And she was drinking all night and drinking the night before all night. I know. Wild. Well, okay, so you guys want to go into these documents? Because there was a few that I just thought was important to read. And one of them is when they asked for the judge's recusal. So because, okay, this is the brief in support. It's a little bit long, but we can skip through the parts we know. And there was, hold on, 2 more. Wait, this is a different one. And then her response. Oh my God. Okay. So let's start with this one. Because there was something else interesting. So, they all of a sudden, Barbara Elmore, in her response, she said that she was not involved with the release of Michael Fossler. And it's like, so Aaron Spencer's team was like, well, we want the documents that they did all these formal requests, for the certified documents of his case and his bond hearing, and they couldn't get them. And then they were told that they were sealed because it involved a child. And they're like, that's not how the law works. Like, we are still allowed to have access to them. So, and obviously she is the one that let him go, because even the Supreme Court cites that. So, but all of a sudden, out of nowhere, she just tries to deny it. And then they send this form that someone else signed that's not the bond hearing form. It's like something else. So it just, like, when I tell you that this is like so insane, it is so insane. So I'm just giving you guys that, like, heads up, because when we get to that part, it might blow your minds. So, okay, so this is the short one. This is the 4-page one. All right, defendant's motion for judicial recusal. Let me make sure y'all can see this. Is that big enough? Should I just move myself? I'll just take myself off. Okay. How many people are here? Okay, so we have a good crowd. Okay, let's keep going. All right, defendant's motion for judicial recusal. Defendant Aaron Spencer respectfully moves for recusal of the presiding judge pursuant to Rule 211A of the Arkansas Code of Judicial Conduct. The cumulative record of these proceedings results in reasonably questions about the court's impartiality. And then she cites a case. This case arises from the killing of Michael Fossler, who had lured Spencer's minor daughter from her home while facing dozens of felony charges arising from SA offenses against her. Fossler was free on bond at the time. Bond issued through this court and was killed during Spencer's effort to recover his child. From its inception, the case has drawn intense public scrutiny regarding the court's decision to release Fossler on bond, the propriety of charging Spencer for actions taken in defense of himself and his child, and the integrity of the local law enforcement given his failure to preserve critical evidence. Spencer, his counsel, his family, and others have publicly criticized those actions. In the early proceedings, the court entered into an extensive gag order, sealed the case, and limited public access without a hearing for or factual findings. The Arkansas Supreme Court granted certiorari and vacated that order, expressly cautioning against courtroom closure or secrecy imposed without adherence to constitutional requirements. And then they cite the Spencer versus State, the Supreme Court case. Several justices warned of a troubling pattern of attempts to shield this case from public view that, in their opinion, warranted reassignment even then. Following the Supreme Court's intervention, the court's subsequent rulings have reinforced, not alleviated, concerns about impartiality and secrecy. The court imposed compressed and impractical scheduling directives while discovery was still being produced, required duplicative filing shortly before major deadlines, and denied defense requests for additional time despite late discovery disclosures by the state. During the pretrial hearing, the court curtailed discussion of Fossler's abuse and its relevance to the defense, permitted the state to proceed with expert testimony despite belated discovery related to that expert, and mischaracterized defense advocacy as improper. The hearing culminated in a public accusation of misconduct against a member of the defense team made without evidence and in open court, resulting in that attorney's removal and exclusion. The attorney violated no rule and did nothing improper. The episode publicly branded the defense as untrustworthy and reinforced the perception of hostility towards defense counsel. So let me tell you guys what happened. So during one of the pretrial hearings, it was, there's no recording or anything. But then during breaks, people would go outside. And so some of the people who were like in the courtroom were like posting to the Facebook and saying like what was going on during the breaks, right? But inside, there's no phones allowed. However, attorneys, and we've seen this, like if you watch any case, like they're always on their laptops and phones because they're coordinating witnesses and whatnot, right? So the attorney was like doing something on their phone. And then the judge found out, like from, I guess that someone told her, the clerk, that like some stuff that had happened in the case had been on Facebook. She went crazy and made everyone go back outside to get research for make sure their phones were off. And then when she saw that defense counsel was on their phone, she blamed them. And then she had them removed from the room and like chastise them in public court. This is all like according to the people that were there. Okay. So I obviously wasn't there. And this is what happens when things are done in secret. We just have to rely on hearsay. So yeah, I mean, and you know what's crazy about this is there was, and I actually remind me, I wanted to tag or cut this part for Omar from the Tilted Lawyer, because somehow this came up in a stream recently. I think that he did with Cassidy, or maybe it was Lauren. And they were saying how like attorneys are allowed to be on their phones during trial, like, like that's just a thing. Because that's what it was. I think he was talking about the hearing for Blake Lively. The people that were going were not allowed to be on their phones, but that obviously the lawyers there would be allowed to have access to their phones, because you're allowed to have access to your phones during cases. That's just how it is. He was saying that. And I put in the chat, I was like, well, that's how it happened in the Aaron Spencer case. But like, of course, no one knows what Aaron Spencer is. No one cared. But I wanted to send this to him because I think this might shock him, because this is really, really, really bad. So anyways, let's just keep going. Sorry for that sidetrack. Okay. Most recently, the court entered a sua sponte order limiting public and media access to trial, capping attendance, and providing no alternative means of observation, again without evidence, findings, or consideration of alternatives. That order functions as a courtroom closure and mirrors the secrecy concerns already condemned by the Arkansas Supreme Court. Viewed cumulatively, these actions create a reasonable perception that the court has responded defensively to public criticism and appellate review rather than correcting course. The appearance of partiality is further magnified by the nature of the trial itself. A substantial portion of the defense will focus on investigative failures by local law enforcement, including the failure to secure and preserve evidence. The court will be required to rule repeatedly on objections, scope of cross-examination, impeachment of law enforcement witnesses, and expert testimony addressing those failures. The court's long-standing professional relationship with local law enforcement create an appearance problem in this context. Regardless of subjective intent, under the unique circumstances in this case, a reasonable observer would question whether a judge with institutional ties to the very agencies whose conduct will be scrutinized can impartially adjudicate those disputes. That concern is further magnified by Spencer's current status as a candidate for public office. Spencer is now a political actor and, by extension, a political adversary of a public official exposed to be a witness in this case and with whom the court has worked professionally for many years. Spencer decided to run for office in significant part as a result of his experiences with these officials and has campaigned on those issues. His criticisms constitute protected political speech, but they nevertheless place the court in a position where its rulings may reasonably be perceived as entangled with institutional loyalty or political context. Recusal is required where a judge's impartiality may be reasonably questioned. Arkansas Code, Judicial Conduct 211A. Here, where the court will preside over disputes directly implicating law enforcement conduct, where public confidence has already been strained by prior rulings, and where the cumulative record reflects a pattern that reasonably suggests partiality, reassignment is necessary to preserve both the reality and appearance of a fair trial. Spencer respectfully requests that the court recuse from further participation in this matter and that the case be reassigned to another judge. Spencer does not object to entry of an order of recusal without a hearing. In the alternative, he requests a hearing on this motion, where for the defendant, Aaron Spencer, asked the court to recuse from this case and seek expedited appointment of a specially appointed judge and for all other relief to which he is entitled. Wow, right? Mic drop. And let me just look it up. Because I know that the new judge, everyone says it's good. Aaron Spencer, new judge. Because it was appointed by the Supreme Court. Let's see. Yeah, some of these articles I don't have access to. Let me see. Okay, I'm going to share this one. Oh, but see, this one, they had these ads and then the sound. Okay. So yeah, Arkansas Supreme Court appoints new judge to Aaron Spencer murder trial. Okay, Chief Justice Karen Baker assigned retired Circuit Judge Ralph Wilson to oversee the trial. So he's retired. Well, anything is better than Barbara. The assignment comes just days after the court removed Judge Barbara Elmore from the case at the request of the defense. Just insanity, right? Let's see if I can look this guy up. Let's see what he looks like. Is this him? Yeah, this looks like him. Okay, let's share this. So I think this is him. But, as we've seen, Arkansas doesn't really update their pictures. So he could be like 100 years older than this. Or, we don't know when that was taken. But that seems to be him. Ralph Wilson. So, but people say that they think that he's, I think, honestly, anything's going to be better than than what we had. So, how you guys doing? Vague says, many special assignments for judges are assigned to retired judges. For example, the Becky Hill and jury situation. Okay. I didn't know that. That's pretty interesting. Yeah. And actually, yeah, because the judge in that case had retired. I don't know if Becky Hill was supposed to have been seen by that judge. Was it Newman? Clifton Newman, I think. Who I loved. I thought he was an excellent judge. I'm sad that he retired. Oh, there's an interview from a few years ago. Okay, so do you guys want to see? Okay, so they filed something else that goes into more detail, so we can read that if you want. Let's see how long I've been going. Almost 2 hours. So I don't know. Oh my God, do I have a super chat? Who is that? Chanel knows. Thanks for covering this. Well, so good to see you. Thank you so much. I really, really, really appreciate that. Thank you. I'm just glad that there's still people that are into this, because we might actually now, well, I think there could be two things that happen. I think now I think the judge, let me switch this screen for you. Hold on. I think that the new judge I think they might like dismiss the case, because if they have to go through all the previous rulings and go over what she's already ruled on, and they find that like I think there's a strong argument to dismiss this case. And so I think that the judge could do that. So maybe this will just be over and he can run for sheriff and become the new Lonoke County sheriff. Or if this does go to trial now like the public access element of this is very, very important, and we might actually see it streamed. So I appreciate you, Shinonos, for like being here. I appreciate everyone for being here, and your super chat is so generous. It means a lot, and it's going straight into the StreamYard fund. So thank you, because StreamYard's a biatch. What animal is cute? Oh, I think she's probably talking about the squirrel emojis. But I do have actually a cute animal I can show you really quick. I just have a quick screenshot. I'll just show this to you. So do you guys, so we can, I'll show you Barbara's response to that, because then she refused to step down, which I thought was very interesting. I'm like, okay, are you sure about that? Never mind. I deleted the screenshot. I was going to show you Gelth, but I think they're talking about the squirrel emojis. Okay. So let's go back. Uh-oh. He was very involved in children's cases. Okay. Oh, you must have missed the episode about the chipmunks. Oh, the squirrels. Okay. Bella says they'll probably dismiss the case now because DFJ is now on it. That's what I think. Oh, I love you. That's so sweet. Yeah. I mean, I wish I made a difference. Honestly, that's why I had to like start with the It Ends With Us stuff. I mean, I did want to cover that anyways, but when I do Aaron Spencer, it just does not get picked up at all. So like, because all my first videos were about It Ends With Us, like that's the YouTube algorithm I'm like stuck in, and anything else I do like it just dies in the ether. So which sucks, because I had like loved doing the true crime stuff. Gal says StreamYard is expensive, $80 for it. Screw that. I know it's such a ripoff. It annoys me, but it works. Like I think it's the easiest one to work for someone that's not like technologically like advanced. Shanona says if he becomes sheriff, we should buy a billboard with his picture that says there's a new sheriff in town. I love that idea. I love that. And I'm gonna link all his stuff after the stream, because I didn't have it ready in this chat, but I have like a whole playlist, which I don't know if any of the mods do have, if you're able to put the link to like my playlist. I have a Spencer, because all the links are in there. If most of those videos have links to all of this stuff, if you can find it. If not, no worries. I can actually, well, let me see if I can find it. Well, I can link it later. But let me see. So I wanted to show you something really quick. Side note, quokkas are adorable. What is that? Oh my God. They're so cute. I don't know what that is, but that's the cutest thing ever. I love it. Okay. So let me close this. I just want to show you guys something. So Okay, so there's two more attachments to what I just read you, but we're going to go back to that. But I just want to show you just so you guys can see. So this is like her response. And like, I just like, this is so funny. Look at this, like her 24, what is this? Like a 25-point font, like 30-point font that she writes in. So this is a response for judicial recusal. On this day, the court responds to the defense motion counsel for judicial recusal. Many judges set bonds and see defendants at first appearance in the 23rd district. The judge appreciates the work of all other judges that assist her with setting bonds and doing first appearance. This judge never saw the deceased, Michael Fossler. Also, this judge did not set the bond of the deceased. She's such a liar. Due to discovery in this matter, defense counsel is well aware of these facts. Also, and then now she's also basically saying the Supreme Court lied also. This woman is crazy. Also, defense counsel is well aware that this judge did not sign the affidavit of probable cause for warrant of arrest for the defendant, Aaron Spencer. In November of 2024, the court saw the defendant so that he might please set pretrial and jury trial dates. The courtroom was not closed. Defense counsel may or may not remember the defendant. All counsel and defendant's wife were allowed in the courtroom. This is an extremely small courtroom. Moreover, other defendants with their loved ones and bondspersons were in the courtroom. There were issues with very limited space, courtroom management, and security. Also, at the time, there were a number of instances of the flu. Therefore, overcrowding was an issue. There has been no favoritism to one party or the other in this matter. Defense counsel within the last couple of months tried to enter motions under seal. The court would not allow said motions to be filed under seal. The public, media, and prosecution all have a right to see these documents. Said documents have never been filed. This woman is a psychotic. This is the woman who did the unconstitutional gag order trying to accuse other people. That Aaron Spencer is the only person in this whole case who's tried to like put everything out there. This woman is insane. This judge is going to do her duty as the presiding judge over all criminal cases to give the defendant and the state of Arkansas a fair trial in this matter. The court previously entered an order limiting the number of media representatives and members of the public permitted inside the courtroom during future proceedings. The courtroom does not have unlimited seating, although it is the largest courtroom in the courthouse. After accommodating approximately 100 potential jurors, along with family members of the parties, counsel of record, and I think she means of record, right? And counsel staff, remaining space is limited. As a result, approximately 20 additional individuals, including members of the media and public, may be permitted to enter the courtroom, and such individuals may be required to stand at the rear of the courtroom. As the trial proceeds and jurors are excused or seating becomes available, additional members of the media and public will be permitted entry. These limitations are imposed solely due to space and security constraints and do not constitute a closure of the proceedings. So now she's backtracking because before there was only going to be 20 additional seats for media and public. Okay. That's like nothing for this high profile case. And she's not even saying they have a seat. They might have to stand in the back of the courtroom. But now she's like, oh, no, that I was just saying that because of the, potential juror selection. And when the trial was going to start, like it would change. That's not what she said before. Not only is space an issue in these proceedings, let me make sure you guys can still hear me. Yeah, we're good. Okay. Not only is space an issue in these proceedings, so are management of the courtroom and security are issues. There have been many threats against this court and others involved in the trial process. Prove it. Prove it. Give an example. You can't just say that and not give an example. Also, due to fire hazards, the courtroom should not be packed with individuals standing or sitting in areas that block the doorway. You just said they should stand in the back, you moron. This case should proceed as scheduled, and the judge intends to hear this matter. I mean, what a moron. And then, like, look at her big-ass signature. It takes its own page. She couldn't even, like, sign it down here because she signs in, like, 60-point font. So, glad that's the last we're going to be hearing from her, right? This lady is Delulu as Blake. I know, isn't she? Like, she's absolutely insane. Insane. Okay, so I'm going to show you one more document and then we'll be done, okay? For now, I wanted to give you guys all these updates, and we don't know when I don't think we know when the trial is supposed to take place. Okay. Oops. Let me get back to my screen. This was for, I'm just pulling up one more thing. Sorry, you guys, 1 second. And actually, I'm going to get some tea while we're paused. Okay. Let me remove this. That's a cute animal too, isn't it, Kel? I showed this to Christina the other day. I have to do like, I think I'm gonna either like make a little short on it or something with the animals, because this is a ringtail and it was like in my house. Long story, but yeah, and I had to get him out and he was so cute. So anyways, hold on one second. Yeah, Lori, you're right. No, there's no trial date yet. Is she is she insane in the membrane? She's insane in the membrane. DFJ has released my need to hate this woman so much. And isn't that amazing though? Like when we see something wrong and then something's really actually done about it. Like this, like I've seen like Judge Lyman, I think is terrible, but I know he's not going anywhere. But I think he's terrible. And I think that it's a conflict of interest that he's on this case. I think he's done terribly, for the Blake Lively case. But like, I think he should be removed as a judge because he's had to step down from like 14 other cases in 2 years, which is so bad. I think there's something wrong with him. He's defective in the head, in my opinion. But we're never going to see any justice with that, right? We're just going to have to just pray and hope this goes to a jury, because then a jury is going to be much more sane and they're grounded and they'll see what's happening. But, this woman, I mean, imagine how many other cases have been before her that she's messed up. Think this was a high profile case. This man is a legend. Aaron Spencer, in my opinion, he's running for sheriff. And so it's getting a little bit more attention. If there were truth that she wouldn't need any other excuse. Exactly. Thank you, Vague. You're the voice of reason. Thank you. Yes. Can I read the response to that? Okay. So we're going to read the response. Well, there was because there's a lot longer attachment with other things, but okay. Let's read the response to that because I have that as well. So let me make sure I close this one. This was the long one. This is a lot more case law, but because this was attached to the one that I read before. But so I don't want to have to read all of that today, but let's see. I wanted to show you their response. So, oh yeah, and this was the exhibits too that they had, like their emails asking for. This was them. Let me make sure you can see this. Let me take me off. Okay. Yeah, these were some of their exhibits because they're like that they were trying to get these records from Michael Fossler, and like they're just saying the Lonoke County does not have any records of Michael Fossler. So all of a sudden they don't have the records. And they're like, what? How could you not have any records of him? And they're like, no one named Fossler. And then they asked for like the full file. And then they like have to follow up again. And then it says then they say, oh, okay, this is a clerk. Okay, we attached them. And then they don't attach them. They're like please send all documents in this case. Only 2 documents are sealed, so I would expect only the orders related to those 2 documents, and please send all documents reflecting the bond decision. And then they're told, let me see, because it was like they sent like, what is it? This is nothing. Like, I don't know what that was. Oh, they have his charges, right? They get his charges. I mean, the 43 charges, like it's unheard of. Okay, good. You can still hear me. Okay. And then they're like, where's the like other file? Was there not a bond hearing? And then it says, they said, there would have only been a first appearance after his arrest that is not placed on record. And then his plea and arraignment was waived, so there was no appearance. And of course, his case is now closed. Let me know if you need further assistance. And they said, okay, we want a transcript of all the hearings. And then, but I have to show you where they said it was like, yeah. And then they just do a pretrial order, which is not the same thing. This is not a bond hearing where someone else has signed this. So then they ask again, right? And then where was it? The clerk basically says, oh yeah, here it is. I'm waiting for permission from the TCA to obtain certified copies of these documents. And they're like, you do not need permission. These are public documents. I mean, insane, right? It's just so insane. So anyways, okay, so let's go to the other document. So we'll go to their response to that. So response to, okay, so that was her response, right? For judicial recusal. And then here's their response. Reply. So this is reply to clarify the record in response to the court's response to motion for judicial recusal. Okay, are you all still with me? We'll just read this one. Sorry, DFJ, taking you off isn't on my bingo card for today. Try later. Taking what? Oh, that's so sad, gal. Ringtails are a pain in the butt here in Australia. I'd advise to watch the more Pars videos on them. He does the subject. Okay, well, I have to disagree. Well, my research on them said that like the miners, like, well, in America, like would keep them close by because they do like pest control, and they would keep the rats and stuff away. He was such a little sweetheart. But I've read that they're building into places where they live, and so now like more people are getting them in their homes. But like he was just, oh, he was such a sweetheart. Don't worry, you're not going to piss me off. I always love hearing everyone's opinions, but I think that they're the cutest person ever. Okay, so we're gonna keep going. I know, it's so cute, right? We're gonna read this one. So this will be the last one for today, and then I will let you all go. Okay. Sorry, I just need to pull it up. I already forgot what screen I'm on. Okay. Reply to clarify the record and judicial response to court's response to motion for judicial recusal. The defendant, Aaron Spencer, through his attorney, states in reply to the court's order regarding its recusal. The court does not address most of the issues presented in the recusal motion. Counsel addressed the bond matter in the motion for recusal, and the court appears to agree that it was set by the circuit court, although apparently not her personally. Despite all reasonable efforts to confirm that information, defense counsel became aware of this after the Supreme Court's decision on the earlier writ as outlined in the motion under circumstances that create other issues of concern. As pertaining to the closed arraignment, lack of space for the public was not an issue. There were empty benches in the courtroom at arraignment with plenty of space for members of the public and press. The courtroom was not even half full when Mr. Spencer appeared before the court, which was more than sufficient space for the members of the public who were made to wait outside. As the record of that proceeding confirms, the court made no remark at arraignment related to the size of the courtroom or overcrowding in response to defense counsel's objection to the closure. The court is correct that counsel was required to identify the defendant's family, and other than counsel, only they were permitted in the courtroom, that's wrong. Our courts are open to the public. Arraignment was conducted on December 2nd, 2024. There was also no flu epidemic at that time. In fact, it was a normal year for the flu. CDC data shows that Arkansas had minimal flu activity at the end of November of 2024, which was 2 days before the Monday hearing. No other flu-related precautions were taken, such as masks or distance requirements. The documents requested to be filed under seal were properly subject to sealing under the law and logic. The court's order indicated that no documents would be filed under seal, not that there was no legitimate reason that those specific documents should not be sealed for the reasons explained in the motion. As to the court's restrictions on the public's attendance at trial, the court appears to suggest that it will permit the courtroom to fill to capacity. However, that is not what the court's prior order outlined. Given the amount of space and available seating, the courtroom will not be close to full with 55 people, including parties, counsels, and family, permitted to attend the trial. The number permits about 20 to 25 members of the public to attend. In addition to the parties, counsel, and family, the court required the parties to identify. At pretrial, the court reserved seats for family and counsel staff, so those seats were not available even if empty. There is no need for attendees to stand or sit in areas that block the doorway for the public to be permitted to fill the empty seats in the courtroom. The gallery alone contains 75 seats, not including seats along the walls of the courtroom, counsel tables, or a separate conference table that sits empty for the most part. The courtroom also has extended empty space that could serve as seating without blocking any other areas. Further, there are other methods by which the court can ensure public access that have not been considered. There is no record for any threats made to the court or parties. The court has never mentioned this to defense counsel. Spencer has nothing to do with any threats and has not been made aware of any threats. If there have been threats made to the court, it would be unnecessary for security measures to target Spencer during the trial, as the potential danger would be elsewhere. If the court suggests that there's a need for an overabundance of security, as was at pretrial, an adequate record should be made on the issue, along with a balancing the Spencer's constitutional concerns and a narrowly tailored plan to ensure safety, with the parties given the opportunity to address any issues on the record. The court denied the motions to recuse without conducting the requested hearing. As such, the defendant files this pleading to ensure the record is clear on these points in the event there is further review of this court's refusal to recuse from this matter. I just love his attorneys, and we're gonna end it here. But I just once again, if you are on this docket here, let me share with this one. I think it's worth it. Like, if you are still blown away by all of this, to read. See here where it says like the two attachments. One of these is 26 pages, or this one's 52. This one's just exhibits. Okay, the other one, the second one, is 26 pages. This is also a really good read too, especially if you like case law and stuff, how they spelled it out. But like, we're not going to get into that tonight. We've read a lot today, and I just wanted to give you all like the big news and celebrate it with like you guys are like my favorite people. We've been through this case together from the beginning. So yeah, I think that's it. So if there's no other questions, and I think I got everyone, let me make sure I say thank you again, Kinney, for becoming a member. Thank you, Khaleesi, for becoming a member, and for becoming a member for 2 months. That was so sweet of you. Thank you, K Bella, for the super chat. Thank you, Mrs. Busted Can of Biscuits, for becoming a member. Oops. Thank you, K Bella, for the super chat, and thank you, Shanonos, for the super chat. It is so much appreciated. I appreciate all of you. Who is on right now? Should I send you all somewhere? Oh, and thank you to Christina for my mods. Absolutely. I love you guys so much. You have no idea. Thank you. Thank you so much for being here and always being so supportive. Thank you, Kenny. And I want to send you all. Is there anyone else live is there anyone live I should send you guys to? Let me see. Let me, because I have to go into edit. Now I remember how to do this. And then I go to custom, redirect. I don't see any of our peoples. Let me see. Well, Cat says Cat Not Williams upcoming. What time is that at? Let me see what you are all saying in the chat. Who is this? What link is this for? Oh, thank you. Kenny's song. Thank you for putting it in the chat. Thank you. Thank you. Well, I'm going to end it here. So thank you all again, and I hope to see everyone soon. Okay. I'll just link it. Let me just link it to, I see Cat Not Williams says it's eventually. Oh, that's tomorrow morning. Forget it. All right. I'm going to end it. Love you guys. Talk to you soon.